These are the following demands which we have. Number one, the issue of registering cautions. Cautions should be registered upon presentation of the requisite documents. Because you are receiving conditions that you have to come with the person with whom you want to register the caution against. Utampata wapi? Utafanya aje akuje? And that is the person with whom you have the dispute. In practice, a caution is registered once the requisite documents are presented by the aggrieved party. So we are demanding that cautions be registered as thus. Secondly, searches and green cards to be issued to advocates upon presentation of a practicing certificate and a letter requesting the same. The issue of telling us to come with a title deed, telling us to come with a court order, that is delaying justice. And that is unnecessarily putting the litigants through unnecessary costs, because to go to court you have to pay. It takes time. And sometimes we have issues which are very urgent that need the search and the green card. So we are demanding that once, as is the norm, once we have put our letter requesting for the green card and the search, and we have paid the requisite fees, the same should be issued without delay. Now, several advocates have been trying to get into the office of the land registrar to address their issues, which necessarily cannot be handled at the counter. The land registrar has been refusing to see advocates. He's an advocate himself. And that is why we are demanding that as a public office, and as we, the advocates, are the backbone of the legal sector, we have to be given access to his office whenever we have an issue that needs to be handled personally. Now, there's an issue of the power of attorney documents. Now, a power of attorney is the document which allows someone, you donate power to someone to act for you in matters to do with land. Now, the land registrar is demanding that we come in a certain form, which form is normally impractical. As long as the contents of the power of attorney reflect what the rules in the Act say, the power of attorney must be admitted and must be registered, because that is the law. The issue of putting necessarily and unnecessary hurdles, we say no to that. Now, we have an issue with conducting succession proceedings. Whenever we have received a confirmed grant from the court, the confirmed grant is a document which allows you to change names from your deceased benefactor to your name as a beneficiary. The land registrar is telling us to bring original documents from Nairobi, which documents are only in the custody of the offices, the relevant offices. Once a court has issued a confirmed grant, the same must be registered, because that's a court order. What the land registrar is doing is akin to being in contempt of court orders, and that is why we are saying that the issue of telling us to go and bring an original gazette notice from Nairobi, to bring all the beneficiaries again to the land registry before him, is like conducting another succession course. And that is why we are saying once a confirmed grant is brought here and the administrator amekuja na kipande yake, they must be registered in that title deed. Now, up and down, if you can see the counter there, we have about 3 staff. The number of people who come for services here, we have more than 100 people a day. That is why you find long queues here. You find people wanaambiwa rudi ukuje kesho. We need more staff. And that is why we were even trying to get the county commissioner to have him even donate some staff from there for the clerical duties at the counter. We need more staff so that the services can be given without delay. Finally, the policies that the new land registrars are bringing, of course, I know he wants to like streamline the service delivery here. But a complete overhaul of the systems will bring issues. He's here.
Join us. Maybe County Commissioner kindly request him to join us so that we have one meeting.